The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Mr. Nahart, whenever you're ready, we'd be pleased to hear from you.
Thank you, Your Honor. Your Honors, and may it please the court, my name is Seth Nahart. I am appointed counsel to represent Mikkel McKinney. And Mr. McKinney received a sentence in the Eastern District of North Carolina that is on appeal here today. Mr. McKinney was sentenced to a very large variant and all departure sentence, so approximately 344%. And his case involved death in which the court applied the death results departure, a second departure on the basis of uncharged conduct under USK 5.21, and also a variance all to 120 months.
Do you, what do you have in terms of are you appealing the procedural reasonableness of the sentence or simply the extent of the variance?
I am appealing both the procedural reasonableness of departures and also the extent of the variance.
Well, there's there's often some confusion between what belongs in the procedural reasonableness box and what belongs in the substantive reasonableness box. Could you tell me what wherein you think this was procedurally reasonable? I mean, I don't think probably the extent of the variance is a question of substantive reasonableness more, but just tell me about the procedural reasonableness that you take issue with.
Thank you, Your Honor. First of all, and I think the main issue with respect to procedural reasonableness is the causation requirements for finding that death resulted from drugs that my client had sold to a victim. And
well, can we say with certainty that the judge relied on the death enhancement as opposed to 3553 factors?
Well, first of all, you can't necessarily separate those, Your Honor. I do believe that his analysis of the 3553A factors was driven by the question of a death resulting from my client's activities and also, admittedly, other aspects of his criminal record. But
as far as the death results, that's an enhancement that was used to reach the guideline range of 21 to 27 months, was it not?
No, Your Honor, it was the guideline range did not take into account, I don't believe, the death results other than by, I think I'm not sure if the cross-reference hit, but actually I believe it was in the transcript, an analysis under the departure provision of 5K2.1 is my understanding of the record.
Counsel, to follow up on Judge Floyd's question, even if we were to assume that the departure analysis was incorrect, there's a separate variance analysis. So they were decided in the alternative. So even if the departure analysis might have been inappropriate just assuming that, how does that affect the variance analysis?
There's two ways. First of all, if the departure were inappropriate, then you have a situation where, in general, the same risk is involved in fentanyl, but if death is not established to be caused by or resulting from the defendant's drugs, that is a major factor, but not the only factor in the district court's analysis. So,
but I'm still trying to get the procedural reasonableness of this. As I'm not sure I understand where you're objecting to procedural reasonableness. I assume that arriving at a guidelines range is a proponent of procedural reasonableness to get to the guidelines range and correctly calculate it. Now, wherein do you think that the guidelines range was not correctly calculated? Because I don't understand that.
There was not an issue as to the underlying guideline range, is my understanding, and I didn't raise
okay, fine. So, all right, let me just get that clear. So the guidelines range, the 21 to 27 months, you're not contesting that.
That's correct, Your Honor.
Okay, I just wanted to make sure. It's rather the extent of the variance. Well, why wouldn't this fit within the 35? I think Judge Agee raised a good point. You can set aside the departure analysis. It's not to think it's necessarily wrong, but what about the variance? Was it the variance? Was it inadequately explained? Did it rest on? Because I think that goes to the substantive reasonableness, and I'm not sure. I understand that you don't like it, but was it not sufficiently explained, or did it rest on clearly erroneous factual findings, or were there things that were taken into consideration that did not relate to the 3553A factors? I mean, I'm just wondering what your problem with it is. It's an extensive variance, but just superficially, at least, it seems like the things that were taken into account were things that related to one of the third or another of the 3553A factors. And it seems to me the district court was trying to explain this extensively. I just want to know where your quarrel is.
With respect to the judge's explanation, I would concede that he did lay out a number of factors, but his explanation was also inextricably tied to the previous finding, which wasn't explicitly put out in the testimony. And I do agree that it is but for causation under Burrage and this court's subsequent case in Young versus Antonelli.
So is your argument that for a variance that the court has to apply Burrage?
My argument is that the court is one of the factors going into the variance. The court the fact that the court did not correctly apply Burrage, or at least make an explicit statement that it was doing so after being raised by.
But why would Burrage have an effect in the variance analysis under the statutory factors?
One of the statutory factors is the calculation of the guidelines, and my contention would be that
right, but you just
departure would go into that.
Excuse me, counsel. You
Yes.
just indicated in response to my question that you had no quarrel with the guidelines range, and I think that's perfectly reasonable. And then, as Judge Agee pointed out, in determining the guidelines range, that's when you apply Burrage. And if you have no problem with the guidelines range, and Burrage is a part of applying the guidelines range, and as far as I can see, Burrage and Young v. Antonelli, both are harmonious in requiring a but-for test, and that's what he applied, and he arrived at the guidelines range. So I'm not sure how Burrage figures. I have the same question Judge Agee has. I'm just not sure how Burrage figures into the 3553A variance analysis. I do think it figures into the guidelines calculations, but I'm not sure about the variance analysis. I think there you just have to ask a different kind of question, which is, did the district court give you a chance to contest the variance? Did he adequately explain the variance? Did the variance, were the variance findings clearly erroneous? Did the variance findings relate to 3553A? And I'm not sure, I guess the whole thing is, I'm not sure what your quarrel is.
Well, Your Honor, with respect to the variance, part of the substantive reasonableness analysis and part of what appellants counsel in criminal cases often, and myself at least, feel almost required to bring in cases like this is an argument that also looks at the extent of the variance, and that is a portion of substantive reasonableness. And so in that respect, I would, under the variance analysis, I would contend that it is substantively unreasonable for a couple of points. First of all, government counsel has helpfully given the court a chart in its supplemental briefing on page 25 and 26 of court's variances in drug trafficking cases, and this would be very much on the high end. If one of the issues of the court below was the risks involved in fentanyl that Judge Dever went over, I think, in the record. And if you're not establishing a death as being caused by the defendant's drugs, my argument would be on a substantive reasonableness analysis, that's a factor that is out of whack or is given more than appropriate weight if it's not been established. But,
Counsel, let me ask you before your time runs out. The First Circuit decided a case recently called Heidenstrom,
yes,
which seems to be very factually similar to this case. And if anything, the facts here are even stronger for the government. Why shouldn't we just follow that case here?
Well, there's a critical distinction in the Heidenstrom case that in Heidenstrom, at least with respect to the but-for causation, there was an explicit finding by the court, and also there was explicit testimony to that ultimate issue. And those explicit testimony by the expert and or the explicit finding by the judge are missing in this case, I would contend.
Well,
I thought the first, go ahead.
No, go ahead, Judge Agee.
No, I was just going to, I thought the point of the First Circuit's ruling was that the district court judge was very clear that regardless of the circumstances, this was the sentence that the judge was going to give.
Yes, Your Honor, and it is parallel on a number of cases. I would contend that I would concede that on the variance analysis, it is a very close to our current case. I would ask the court not to follow it in that respect.
All right, thank you very much. Judge Floyd, would you like to ask any questions of counsel?
No, I don't have it.
You okay? I didn't want to move on to Mr. Bragdon if you had any questions.
I'm fine. I don't have any questions.
Okay. Good. Judge Agee, you okay?
Yes, sir. I have no further questions at this time.
All right. Thank you, Mr. Nehart. And let's hear from Mr. Bragdon. Mr. Bragdon.
Good morning. May it please the court. My name is David Bragdon, and I represent the United States. I think to answer some of the court's questions regarding the substantive reasonableness and the alternative variance, for the district court's alternative variance, I think substantive reasonableness is the only question that was raised here. I don't think there's a procedural reasonableness question there. And I do think the analysis does not follow barrage for that question, because I think the court can look at this defendant here was engaged in incredibly dangerous conduct. He knew that he was distributing a very potent and high-powered drug, specifically fentanyl, and he knew that it was risky. He knew that there were overdoses being caused, that this victim had actually reacted very strongly the first time he took it. And he was warning people that be careful, this is dangerous. And so I think the variance is appropriate based on that. And whether or not, the specific causation standard of, was there but-for causation, was there proximate cause? I don't think that analysis comes into play at the variance stage. And so I think that the judge's decision is warranted.
So you say that the variance was not based on a finding of causation of death?
I think the court made an alternative holding here. And I think
he did do that. He did say that.
So I would say yes. I mean, I think the focus of the court's conduct is on the defendant's culpable behavior in distributing this very dangerous drug. And so I don't think that alternative holding depends on the specifics of causation.
Which alternative holding, the variance?
Yes. So he made three holdings. There was the 2.1 upward departure, then an alternative departure under 5K 2.1, and then the alternative holding under 5K 2.21, and then the alternative variance. So there's sort of three supports for the same decision. And
why wouldn't the variance analysis be a straightforward way to get at it?
I think it is a straightforward way to resolve the issue here. So I don't think the court has to grapple with the causation questions related to the two departure issues. I think we win under those. I think the evidence is very strong there, but I don't think that is raised by the court's alternative variance.
I always thought that those causation questions and everything were part and parcel of the guidelines calculation. And that the Burridge and Young v. Antonelli and but-for causation were primarily utilized in calculating the guidelines range. And there's no challenge here to the guidelines range. Is that correct?
It is correct that there's no challenge to the guidelines range. I would say, though, that I think we would agree with the defendant that there is a but-for causation in these in the 5K 2.1 departure analysis.
If we're using the 3553A variance analysis, do we get into that?
No, you do not. You do not. So because the court made an alternative variance holding, the court does not need to get into that at all. It would only get into that if it were analyzing the court's departure holding. And I did want to just note, in terms of the size of the variance here, I think whenever you have a very low guidelines range, the variance seems a lot higher from a percentage perspective. But I wanted to note that had the defendant actually been convicted of this drug distribution resulting in death, and had the government charged him of this, prior drug conviction that he had, his guidelines range would have been 360 to life. And had he just been convicted of the drug resulting in death without the past criminal conviction, it would have been 235 to 293 months. And so I think
let me ask you a question. I want to make sure that we wouldn't be opening the door to all kinds of variances in these drug cases when death results, and as but-for causation. So what can you point me to that are limiting factors in cabining this variance analysis, factors that are unique to this case that wouldn't just be applied willy-nilly across the board? What do you focus on that, in your view, is distinctly egregious about what happened here?
Well, that's a great question. I think what we focus on is the defendant's callous indifference to life here. And we see that in his text. We see repeatedly him saying that, be careful because people are going out on this drug. And so he's texting that. He was, thinking, and I'll quote, there's some profanity, but quote, thinking about dude asked earlier, MF couldn't even walk, talk, think. That MF was gone, bro. He's referring to the victim here who had taken his drug earlier. He then texts another customer saying, please be careful, it's really strong. And this is a customer that he just sold crumbs to, not even, full rocks or anything like that. And so I think what we would focus on is the defendant's knowledge that this is very dangerous.
All right. Well, so does this variance analysis apply to every fentanyl crime? There's always the dangerous drugs, and it's common knowledge.
I think that the definition of a variance is that it's a discretion for the judge in the specific facts of the case. And all fentanyl is not equal. All quantities are not equal. There's lots of people who take fentanyl and there's much lower risk or less risk of death. I think what makes this unique is even by fentanyl standards, this was a very powerful dose of the drug, and the defendant knew it. So I think that's what makes this particular case unique. And I do think that we do have evidence here that it did cause the victim's death. And so I think that's another significant factor that the court could consider.
I think the district court made a finding that he had seen the defendant, that he had seen the deceased stumbling out of the bathroom. And so I think there's a finding there that he had actually seen him in a drug-induced state to begin with, and that you had the doctor's testimony of the shocking level of the fentanyl in the decedent. And you have the fact that he is shaming the defendant for going to Durham when he had fire of his own. So what I'm looking at is just, I think that the facts here are just awful. But at the same time, I don't want to just throw open the doors to a large percentage variance in a case that doesn't have the kind of egregious facts that this one did. I mean, it's only one step away from an actual homicide here. Because in order to make a profit on his drug distributions, in order to get a little bit more money, he not only increased this man's dependency, but he took a terrible chance with his life. And the facts here are just horrible.
Yes, I agree. And I do think the court's concern about other cases and how this would play out, I think that's exactly why this court reviews for substantive reasonableness case by case, is so that both the district court and this court is looking at the facts of each case and not, it's the whole purpose of allowing the guidelines to be advisory in the first place, is to give courts the discretion in specific factual situations. And I think the district court reasonably exercised that here. And I think the other thing I would point to is if the court reads the victim allocution that was made in the sentencing as well, I think that's again an appropriate part of the record and a very powerful part of the record that the court could consider in making its decision. I would note just on the causation issue, because I don't want to let that go entirely. I do think there's three things I would point to show that but-for causation was shown by a preponderance of the evidence and that the district court did not clearly err. First, the timeline strongly suggests that McKinney's fentanyl was the last drug that Nelson, the victim, bought before he died. And I think a reasonable inference from that is that he used the heroin he brought from another drug dealer when he was drug sick immediately after he bought it, because he was drug sick. He then bought McKinney's fentanyl at 10:45 that night, went to bed and used it the next morning. He was alive at 7 a.m. when his roommate saw him, and he died. He was she found him in an overdose state at 10. The second thing I would point to is the defendant. We know that McKinney's drugs were incredibly strong based on his own statements and texts and his observation of Nelson when he first used the drug. And the third thing I'll say is it was the fentanyl, not the heroin, that was present in McKinney's body in an unusually high concentration. One of
Mr.
the
Bragdon,
nine.
Mr. Bragdon, do you contend that the judge doesn't have to use the magical words "but for"?
I think.
Isn't that what you're arguing now?
Yes, we do think when there's no dispute about the standard, and here there was no dispute below, the defendant immediately before the judge rules on this, the defendant says, but for causation applies in barrage. And the judge then, makes this decision. I don't think he has to use a magical term. I think it's clear that he found that the death resulted from the fentanyl use. And I think the evidence strongly supports that here. So,
is it also permissible? You've talked at length about the fact that there is but for cause. Is it permissible for the district judge to take but for causation as one of many factors informing the 3553A analysis?
Yes.
I mean, it's not just a feature of a departure, but it could be used not as the sole or exclusive factor, because I guess that would be duplicative, but it's certainly a lot more serious case for a variance if the but for causation could be used as one of the factors in the variance analysis. There's no barrier to doing that, I would assume.
I do agree with that, Your Honor. I think it can be, in a variance situation, the court can consider all the factors, but for causation can be one of them. The defendant's knowledge and the risk that he took with respect to his customers' lives can be another significant one. And the defendant here also did have a criminal history. He had 3 assaults. He, pointed a gun, into a woman's mouth, I believe, grabbed her by the neck. And so there is, I believe, plenty of support to support the judge's variance. If there's no further questions, I would ask the court to affirm.
Judge Agee, Judge Floyd, do you all have further questions at this moment?
No, sir.
I assume, counsel, that you would agree that this Heidenstrom case could also apply in this circumstance?
Yes, Your Honor. We cited that case in our supplemental brief, and I do believe it's directly applicable here to say that regardless of the court does not have to reach the departure issue here or the but-for causation. It may affirm based on the variance. And the only question there is whether the sentence was substantively reasonable based on the facts. Thank you.
All right, we thank you, and no further questions of Mr. Nahart. You have some rebuttal time, and we'd be pleased to hear from you.
I believe you're muted.
Please.
Yeah, there you go. Unmute, you're there. Now.
I'm sorry, I had assumed I was still on, but I shouldn't have. There's a couple of points that I would briefly like to make in rebuttal. With respect to the but-for causation, I do recognize that I have a number of arguments I need to make to finally get over the goal line, and that is one of them. And the First Circuit Heidenstrom case, I would cite as an example of how but-for causation is shown that wasn't necessarily shown in this case, and that was the explicit findings or the explicit statement first of an expert, when there was a case of multiple drugs and different suppliers at different times, especially, that an expert testimony making that statement is the way for a government to prove but for causation. And I would ask the court to adopt that as that part
Doesn't the doctor's testimony here? I don't think there's any requirement that district judges bring in experts, but a part of the case the district court relied on was the astonishingly high and shocking level of the fentanyl in the decedent. And there was medical testimony from the doctors as to that effect. So that's probably the most relevant expert testimony you could have.
But that expert did not make a statement about that high level of fentanyl actually being the cause of the death. And unless I missed it, I did not see that in the testimony or report of the expert.
What other cause would there have been? This is the last substance that he ingested, and there was a shocking level of that in his system. I've not seen any kind of alternative argument of causation put forward. There's no alternative explanation that holds water.
Your Honor, I would concede that there is not a specific alternative explanation that was advanced below in the record. However, one of the arguments of the government was, in general, expert testimony is not required, and there are a number of cases there, but I would contend as a matter of public policy or a case law that without expert testimony of the type we're talking about here, you really can't say that in a specific case, a drug killed a specific victim when there was a mix of different drugs and different time and different suppliers kind of going into the mix. So I did want to address that point. Second, the government did raise a number of issues with respect to the alternatives, but that is a consequence of defendants' plea bargaining, and the government had made that decision with respect to its own plea bargaining. With respect to the specific differences in the variant here and the specifics of this case, I would contend that below the analysis of the district court is even on the variant very much wrapped up in a finding that my client had been the cause, and my client's drugs that were sold to the victim were the cause of his death. And if you have no further questions, I would thank the court for its time in considering this case.
Mm-hmm. Judge Agee, Judge Floyd, do you all have any further questions?
No, sir, no further questions.
All right. All right, we want to thank you both, and we will, Mr. Nehart, I see that you're court appointed, and I want to express the court's appreciation for your services. Thank you so much. Mr. President, we appreciate your argument very much as well. We will move right into our next case.
court, Mark Jones for Delton Eugene Warren. The Fourth Amendment protects the people from the government. It protects their persons and the sanctity of their homes. And the process of issuing a warrant at common law to the founders and to this day is a serious and solemn event. The warrant requirement is not a bureaucratic or administrative box for law enforcement to simply check. The Fourth Amendment is and has been the levee protecting our privacy. As I said in the brief, we must, of course, look to the text of the amendment in discerning its meaning. But the inquiry does not end there, and the inquiry has never ended there. And to get at it, consider this. In this case, why didn't Detective Brian Tompkins just sign the warrant himself? Well, because it had to be signed by a judicial officer. But why? Because the person checking the government's power has to be neutral and detached.
It has to be signed under state law, but we have several cases, Claiborne is one of them, where we made the point that this is governed by federal requirements and not by state law. And that's, just flatly the case without precedent.
I fully agree, Your Honor. And I don't assert, and I'm not making any state law arguments on behalf of Mr. Warren. And so when I ask about why it has to be a neutral, detached magistrate, why it has to be a judicial officer under the Fourth Amendment, I look to the text, and I have it right here. And the text doesn't say anything about a judicial officer. The text doesn't say anything about a neutral party. The text actually leaves out a number of key things, such as the warrant can't be issued nunc-pro-tunc. Nothing about the text authorizes law enforcement to seize somebody during the course of a search warrant. Nothing in the text discusses the nexus between the criminal act and the place. And so, even though these aren't in the text...
That's fine, but there's simply no requirement there. And what I guess troubled me about your case is it seemed that this was just the most minuscule little picking at something. And when the state judge had made the notations on the warrant, and the state judge had signed the warrant application in a number of places and entered the 2:40 p.m. as the time it was issued box. But it signed the warrant affidavit. And then the First and 10th Circuit said that an unsigned warrant was not fatal if there were subsequent reliant statements of intent from the issuing judge. And here the state judge explained in a signed statement that it was simply an inadvertent oversight that had left that unsigned. But that you look at all the places that she's made marginal notes and signed and everything, and then her signed statement, and there is simply no room for doubt that she approved this and signed, and that she issued it, and that she found it was a valid warrant. It's just so you're sort of taking a minuscule pick at something that's perfectly clear.
With respect, Your Honor, I could not agree more or not disagree more that the error here is minuscule. And I think that it is fundamental, and here's why. All of the
Mr. Jones, let me ask you before we go down that road. Why can't we just decide this case against you under the good faith exception and without having to reach what the First and the 10th Circuit did?
Because there is no way a reasonable law enforcement officer can look at what was returned to Brian Tompkins, the detective, and believe that that is a validly issued warrant. And I think the best place to look, Your Honor, for that is Joint Appendix page 43. This is a copy of the warrant or the document that purports to be a warrant before it was executed without notations on the left-hand side. And document 43 is what would have been given to Delton Warren. And in the very middle of it, there's a giant hole for the authorization or for any assurance that the judge has the authority, or that the officer has the authority to seize Mr.
Well,
Warren.
he applied for a warrant. He got a warrant. He executed on the warrant. What? I don't understand what's wrong with Judge Floyd's suggestion. That, I mean, you want officers to do these kind of things. You want them to apply for warrants, and when they get a warrant, you want them to execute the warrant in accordance with the law. I mean, I don't understand. I think your case is weak on the merits, but I do think this is a classic situation, as Judge Floyd points out, for Leon to apply.
And so the reason, Your Honor, why Leon doesn't apply, and the reason why what the detective did in this case is insufficient, is that it undercuts and completely destroys the meaning of the Fourth Amendment if a signed and completed warrant application is sufficient. Of course, we want the officers to do a warrant application. Of course, we want them to do.
Well, but here you've got more than that, because you've got this. It's already been mentioned. You've got the issuing judge's affidavit. It just seems like to me, whether we're looking at this as a on its face Fourth Amendment analysis or a Leon claim, your only refuge is to say that there's a per se requirement that cannot be waived for a signature of the issuing judge on the face of the warrant.
I think that's correct, with one modification, Your Honor. I think that there is a per se requirement that either the signature or some assurance of authority of the issuer be on the face of the warrant. And that comes from, I believe, the Supreme.
Well, but the police officer saw the judge sign every other page that was attached to the warrant, and he saw the judge write on the face of the warrant.
The testimony was clear that he saw the judge initial in the style of the case. And it truly, I think, is difficult for any law enforcement officer to look at, or anybody to look at, Joint Appendix page 43 and believe that this is a valid and signed warrant.
Well, what gave the officer any kind of notice of that? I mean, you're gonna when the officer sees that this judge is initialing the warrant and everything else, what gave the officer any kind of real notice that this was an invalid warrant? I mean, Leon makes the point over and over that you deter police conduct that needs to be deterred. But this is not something that needs to be deterred. It is at most, a small inadvertent mistake on the part of the issuing judge, and a fine point with respect to the warrant, which the officer had no notice of. I mean, I think probably 9 out of 10 officers in the same situation would have thought this to be a valid warrant. And this is not, what happened here is not outrageous police conduct that needs to be in some way deterred. And that's what that's the point that Leon makes, is this is what we are talking about here is purely technical in the smallest and most minute sense. And to hold the officer blameworthy in this is just, I can't understand it.
So with respect, Judge Wilkinson, while you suggest that this is a minuscule or technical oversight, to me, the onus on the officer is so minuscule here. Simply look at the face of the document, right? I mean, the officer has, by his own testimony, sought hundreds of these. And he testified that the way in which he gets permission to exercise the state's power is by the judge signing it. And so the officer knows that the judge signing it and signing it in the middle of JA 43 is how the court gives its permission. But here I think is the important part. The argument by the government is that there is no signature requirement in the text of the Fourth Amendment, and that that's the end of the analysis. But we know that the Fourth Amendment was built on a common law understanding. I identified earlier a number of different requirements that relate to the Fourth Amendment, none of which are in the text. And in this case specifically, the magistrate judge got into this Fourth Amendment analysis. It cites Starr versus United States. The cite for that is 153 U.S. 614, and it's at page 192 of the Joint Appendix. What the Supreme Court of the United States did in Starr is to analyze the common law foundations upon which the Fourth Amendment warrant requirement was built. And in the Supreme Court's own analysis, it goes through Hawkins and Dalton and Koch and Blackstone. And it cites Book 4, Chapter 21 of Blackstone's commentaries for the common law understanding that a warrant had to be underhand and at the time under seal. And the reason, Your Honor, why it had to have those requirements was so that the public could have assurance that the person executing it had the authority.
Let's talk about the real world.
Yes.
There is no real world invasion of anybody's rights here. Nobody's privacy rights have been sacrificed by what happened here. If you talk about the real world, human beings are not perfect, but in this case, they were pretty darn good. There's a state judge who was conscientious both in preparing the warrant and in the signed statement afterwards. And the officer was conscientious in seeking the warrant and in believing that it was valid for him to execute upon it. And when you get down into the Fourth Amendment is obviously one of our most important amendments, and no one wants to abridge it. But at the same time, you have to ask yourself, were somebody's Fourth Amendment privacy rights really sacrificed here? Were the police and the state judge really out of bounds? I'm talking about the real world. Nobody's privacy rights were in any way, shape, or form compromised.
So I again disagree, and here's why. Because an officer of the law may not enter into somebody's house without a valid warrant, regardless of the intentions. They have to have a warrant. And I believe it's the Supreme Court in United States versus Chadwick, 433 U.S. 1, which has said the signature or other indication of authorization on the face of the warrant assures the individual whose property is being searched or seized of the lawful authority of the executing officers.
Well, I'm glad you didn't omit the phrase or other indicia of authorization.
That's correct.
You might want to read Leon to us while you're at it.
I think that either the signature or other indicia is critical. And that's why the Supreme Court in the Starr case discussed the signature or the seal. And what it held was that we don't always need the seal where we have the signature, which is that other indicia of reliability. And the real world consequence, Your Honor, is that when officers go to execute these documents, or when the people are faced with something that says you may come into my home or seize my person, there needs to be assurance on the face of that document that that officer has the authority of law when doing that. And that's what the signature or other indicia of authorization.
The Supreme Court has applied Leon even in situations where probable cause was not present. But they said, all right, there's still good faith reliance on a warrant. Here, your entire argument has not even suggested that probable cause was not present. That's just what I'm talking about in terms of the real world. You've made this argument and you haven't even gotten to the real world implications of this, which is that you haven't even suggested that there wasn't probable cause here. So the officer knew what he knew. He'd seen the state judge sign the warrant, and the state judge's markings all over it, nobody's rights were harmed. That's the problem.
And I see my time has expired. I do have two answers, though, to your
It
question.
hasn't expired. You've got some time for rebuttal.
Fantastic. So two things. One, the reason why Leon is inapplicable here is because the detective, and this is where state law actually does come in, the detective wasn't seeking a federal warrant. He was seeking a state warrant. And the state law required that JA 43 look drastically different. And he had all he had to do.
Well, you haven't even mentioned our Clyburn case and the idea that this is in a state statute, but there's no similar idea expressed in a federal statute.
Yes. So the point, though, was as this judge walks away, or as the detective walks away, he should know right off the bat, the state law just being one thing to alert him to it, that this is not a warrant. But here's the point about probable cause.
Counsel, you've had some extra time, and I think you will agree with me that the bone has been chewed. Maybe not satisfactorily from your standpoint, but it has been chewed. I'm going to ask Judge Agee or Judge Floyd if they have any further questions, and then we can extend your time if they have further questions.
No further questions.
I don't have any further questions.
All right. Thank you, Mr. Jones, and we look forward to hearing from you in rebuttal. Mr. Rhodes.
Morning, Your Honor. Thank you. May it please the court. My name is Chad Rhodes. I'm an assistant United States attorney here in the Eastern District of North Carolina. It's my honor and privilege to argue this case before you today in the case United States versus Delton Warren on behalf of the United States. I will first focus my time on the Fourth Amendment issue, and then I'll move on to the good faith exception. I know that some of the facts have already been discussed in this case, but I think it's important to explain what happened practically in this case and what happened with how the warrant was actually obtained. This case comes from a drug investigation into Delton Warren. In February of 2017, there was a tip that he was selling drugs. There were controlled purchases made. There was a trash refuse pull done to develop probable cause for a search warrant. In applying for that search warrant, Detective Tompkins provided statements under oath in the form of a probable cause affidavit. He identified Mr. Warren's residence as the place to be searched. He identified what items would be seized in relation to that search. In turn, the issuing judge signed every page of the affidavit and the warrant application. In addition, the issuing judge filled in by hand the defendant's address on the warrant and wrote in the time at which she issued the warrant, followed by her initials. However, as has been pointed out, she mistakenly did not sign the warrant itself. After the judge handed the warrant to Detective Tompkins, he went and served the warrant, executed at the residence, and recovered a significant amount of drugs, money, and a firearm. The narrow question for this court to decide is whether the failure of the issuing judge to sign the warrant otherwise invalidates a warrant that complies with the requirements of the Fourth Amendment. The plain language of the Fourth Amendment outlines what is necessary before a warrant may be issued. Specifically, the warrant must be supported by probable cause. It must describe the place to be searched, describe the items that will be seized, and the facts supporting probable cause must be done under oath or affirmation. Nothing in the Fourth Amendment requires the issuing judge to actually sign the warrant, nor does it require specific signs of issuance. The First Circuit and the Tenth Circuit, on extremely similar facts, reached the same conclusion. Failure by the issuing judge to sign a warrant itself does not invalidate the warrant as long as it complies with the actual requirements of the text of the Fourth Amendment. Here, the warrant complies with the textual requirements of the Fourth Amendment. The warrant was supported by a probable cause. The person seeking the warrant, who was Detective Tompkins, did so under oath or affirmation, and the warrant described the place to be searched and what would be seized. The judge found the warrant was supported by probable cause, and she issued the warrant. We know she issued the warrant because she wrote in the time that she issued it, and she made modifications to add the defendant's address. There's no reason for the issuing judge to make those edits to the warrant unless she intended or actually did authorize it. Her inadvertent failure to sign the warrant itself was an oversight, and she actually provided a statement to the government that was used in the defendant's suppression hearing that stated she did authorize the warrant. Specifically, the judge stated that she issued the warrant based on the sworn probable cause affidavit of Detective Tompkins. The magistrate who authored the memorandum of recommendation to the district court concerning how that suppression hearing should be ruled on found that evidence to be compelling. The evidence both of her handwritten changes to the warrant and the statement she provided during the suppression hearing, and the district court agreed with the magistrate court, concluding that the warrant was both valid and consistent with the decisions in the Lyons and Cruz cases. This warrant clearly meets the requirements of the Fourth Amendment and should be upheld. However, should the court find that the warrant was deficient, the good faith exception should apply in this case, as Detective Tompkins reasonably relied on the warrant itself. The Supreme Court in Leon noted that the exclusionary rule is designed to prevent police misconduct rather than to punish the errors of judges and magistrates. There was no police misconduct in this case, and there's no reason to suppress the evidence based on a judicial error. In evaluating this case under the Leon factors, the magistrate was not misled by information in the affidavit. The magistrate did not wholly abandon her duties as a detached and neutral role. The warrant was not based on inadequate probable cause, and the warrant was not facially deficient. Now, the other side is attempting to argue that because the warrant did not contain a signature that it was facially deficient. But that's not what Leon says. Leon is talking about facially deficient when it comes to particularity as to the place to be searched and the items to be seized. Detective Tompkins' reliance on the warrant was not unreasonable because he met the requirements of the Fourth Amendment. As to his part, he provided a sworn statement under oath, providing probable cause. He described what was to be searched, and he described what was to be seized. His conduct was neither the source nor the cause of the error. Detective Tompkins relied in good faith on Judge Hill's probable cause determination when she signed the application, the affidavit, and made handwritten edits to the warrant and handed it back to him. Thus, in our opinion, Your Honors, the search and seizure should not be suppressed, and we ask that you find it in the government's favor. As far as yes, Your Honor.
What were you going to say?
I was going to say, Your Honor, unless the court has any questions, I'm happy to defer the rest of my time.
Let me ask Judge Agee, do you have any questions?
No, sir.
Judge Floyd?
No, sir.
All right. We thank you very much.
Thank you, Your Honor.
We appreciate it. Mr. Jones, you have some time for rebuttal here.
Thank you, Your Honor. The several points I want to make start with that the probable cause finding or whether or not there is probable cause is just not enough, nor is the fact that the judge intended to sign it sufficient under the Constitution. I fully recognize that the 10th and the 7th Circuits have opinions on this in Cruz and Lyons. My brief cites extensively a different position from a district court in the Evans case. But candidly, I believe that the Evans analysis is the closest one to being correct and the closest one that is in line with the common law understanding and the common law foundation of the Fourth Amendment and with the Supreme Court statement about that common law understanding. And that is that we cannot look to just the text. We must look to the common law. And there is something that is critical about the face of the document itself, so that if the document that is issued does not have either a signature or sufficient incidence of the authority of the issuing officer, it is invalid. That is my position. And this document, JA 43, simply is not a warrant. It is a document that it is so bare of what is required that it does not have sufficient indication of authority of the judge. The spot where the judge's name would be listed is blank. Where the judge's signature is listed would be blank. And simply a initial in the style section that says CH with no indication of who that is doesn't provide to anybody receiving this that this has the authority of somebody authorized by law to issue this.
All right. Do you have anything further, Mr. Jones?
No, Your Honor. I would simply say, in summation, that I believe that the common law understanding of the Fourth Amendment signature or other authentication requirement did not occur here. This was not a warrant, and the evidence obtained from it should have been suppressed, and would ask the court to reverse.
All right. Judge Agee, Judge Floyd, do you have anything further?
Nothing
No,
further.
Judge Agee, do you have anything further?
No, sir. No, sir.
All right, I want to thank you both. Mr. Jones, I really appreciate your argument. I know you're court appointed. I want to express the thanks of the court for the argument that you presented to us today.
Yes, Your Honor.
All right, thank you both. We're prepared to go into our final hear from you, sir. Whenever you're ready, Mr. Cantor.
Are you having issues, Mr. Cantor? Can you speak?
Apologize, Your Honors.
Well, it doesn't matter. We'd be happy to hear from you, and we are glad we can hear from you. So please proceed.
Okay, thank you, Your Honors. May it please the court. My name is Glenn Cantor, and I represent the appellant, Robert Shoup. Your Honors, I'm here today because of what can only be characterized as a gross miscarriage of justice. In 2004, Mr. Shoup, after having failed surgery to treat his horribly painful spinal disease of osteomyelitis, and after a failed attempt to return to his occupation as a chef, was forced to go out on disability. He was paid benefits for 11 years. In 2016, after receiving benefits for 11 years, despite a deterioration in his condition, Hartford improperly terminated his benefits. If the record in this case is examined fully and fairly, it is literally impossible to find the termination of benefits was based on a preponderance of the evidence in the record. Rather,
Mr. Cantor,
Yes,
Cantor,
yes, Your Honor.
with regard, is there any other evidence against your client other than the Wolf FCE in all the 11 years?
No, Your Honor. In fact, I was prepared to go through the litany of the evidence where Hartford found again and again and again that he would not be returning to work. During that,
well, you do, counsel, you do have Dr. Lewis's report. So you've got Wolf and Lewis, and those are the only contrary evidence to the other medical evidence on Mr. Shoup.
Yes, but Dr. Lewis came after the denial, so I thought Judge Floyd was speaking of before the termination. Yes. So, shall I continue?
Yes, please.
Yes. In order to take it all in context, I think you have to look at what occurred during the 11 years before the termination. Starting in 2004, Mr. Shoup underwent no less than 25 interventional procedures in an attempt to alleviate his pain, including a surgery to decompress his spine, 2 separate spinal fusions, the implantation of a spinal stimulator, and countless injections to relieve his pain. The procedures only stopped when his insurer declined authorizations and his doctors deemed there was nothing more they could do in the way of interventional procedures.
So what, counsel, what's our standard of review here?
It's de novo, Your Honor. The district court looked at this de novo, but it did it on summary judgment. And my understanding of the Fourth Circuit law is you will review summary judgments de novo.
So do we owe any deference to the district court, or for that matter to the Hartford's administrative review?
I believe absolutely not. The district court's opinion, I think, is, to be honest, irrelevant to this matter. This court is looking at the facts de novo on its own. And with regard to Hartford, my take is that given the facts, it should be given less than, not only no deference, but it should have deference taken away because its credibility findings are so lacking. Any other questions on the review standard?
No, but I have a question about
when he does question.
When he takes a break from sitting, What does he need to do to relieve the pain, and how long does that take?
Well, I think that assumes facts that there's no evidence that it relieves the pain. If you're speaking of the Dr. Wolf FCE that Hartford ordered prior to his termination, Dr. Wolf said he can sit for 6 hours a day. But what he said was the client, speaking of Mr. Shoup, should tolerate sitting on a constant basis at this time if permitted to stand and walk every 10 minutes to tolerance. So in other words, if he's going to sit, he can only sit for 10 minutes, and then he has to get up and stand and walk until he feels better. We don't know what Dr. Wolf was thinking about how long, but if you sit for 10 minutes and stand for 10 minutes, mathematically, he has to work a 16-hour day to get in 8 hours of sitting work. I mean, it's a ludicrous proposition that Hartford took that report and said, well, that's a reason to deny, because he can sit for 10 minutes at a time.
Well, there's also, I had one of the clerks do a calculation. If we stick to the 8-hour day and 6 hours sitting, those breaks are approximately 3 minutes each time. Is that enough?
I don't think so. If you were to read Dr. Wolf's exit interview after he spent several hours being tested, he says, Mr. Shoup elected to rest on a treatment table upon completing the exam in the supine and side lying positions for 20 minutes. Mr. Shoup showed signs consistent with physical distress, including slow guarded movements, grimacing, forward flexed posture, resting hands on knees, and frequent weight shifting. At this time, his pain after several hours of testing, 1 day of testing, not 40 hours in a week, 1 day, was 7 out of 10. And I'd remind the court, this testing was done while on fentanyl. Now, I mean,
what medications, counsel, what medications is he taking to dull the pain here? There's mention that he was taking opioids to mask the pain. Could you tell me what the medication regimen is?
Well, Your Honor, at the start, he was put on Vicodin. He was then raised up to morphine. That was back in 2006. They moved him to fentanyl. Fentanyl was the strongest drug he was put on. He was taken off because he was developing a tolerance, but he was eventually put back on. At the time of the final termination, the IME performed by Dr. Wilcock found that he was taking OxyContin and fentanyl. And I think, maybe karma is helping my client here. I know your first case dealt with fentanyl, and the court's aware that it's only prescribed for intractable, intolerable pain. This is not a minor pain reliever. This man was in horrendous pain.
But he was taking pain medication the whole time, of one kind or another, and you say it was mainly a combination of fentanyl and morphine?
At the time that he was last tested, which was in 2016, I can't say what he's taking today, of course, but yes, at that time, when he went through the FCE by Dr. Wolf, Hartford's FCE, he was on those narcotics. And Dr. Wolf said, I think he could work, but I have to take into account that his pain could go up considerably if he didn't take the narcotics. And, in your last case, Judge Wilkerson, you spoke about the real world. An employment assessment review was done by Hartford, and they said, first, they cherry-picked the report because they only said 6 hours of sitting and ignored the 10 minutes at a time. But in the real world that we're talking about a man with a horrendously painful back disease who hasn't worked then for 11 years, who's taking narcotics, who can't use his hands, who has cognitive issues.
Well, counsel, let me ask you about counsel.
Yes,
counsel. What are the effects? What does the record show as to the effects of the narcotics on Mr. Shoup, particularly as to his cognitive functions and his mobility?
Well, as far as his cognitive function, there are, I could give you the record sites, but in 2007, there's several different reports talking about the effects on his mental effects. The side effects of the medication were severe. That's at A167 and A1342. Once again, in 2012, his doctor said that Shoup had cognitive impairments from the medications. In 2015, his doctor again noted cognitive impairments from pain medication. This goes on.
Well, how does that cognitive impairment, how define that for me? What is it? What is it when you say he has a cognitive impairment? What does that prevent him from doing or cause?
Your Honor, there's nothing in the record that specifically identifies how it impacts him, other than to say there are cognitive impairments. There was no neuropsychological testing done because there was no point to it. He also couldn't sit and he couldn't use his hands. So there was no testing done. I think we have to go on the common sense approach that somebody who's taking fentanyl and OxyContin is going to be impaired in his functionality. Continuing, I mean, during the 11-year period, I think we also should recognize that at the start of all this, Hartford was so sure he wouldn't go back to work that they offered him assistance in obtaining Social Security. That assistance, of course, was successful. I think we all know it was not altruistic on the part of Hartford to assist Mr. Shoup because it reduced its financial obligation to him from $3,500 a month to about $1,900 a month. And this court is well aware of the Supreme Court's view and this court's view of insurers assisting an insured in obtaining Social Security benefits and then terminating the benefits with no meaningful change in the condition. In fact, when Hartford decided it had paid Mr. Shoup long enough and terminated his claim, it didn't give him a viable reason for why it diverged with Social Security. Hartford advised Mr. Shoup that Social Security employs what it called a unique set of federal criteria, and it falsely advised him that, unlike Hartford, the Social Security Administration does not conduct an analysis of skills that may be transferable to other occupations. That statement is blatantly false. As the court knows, when an SSDI claimant reaches the ALJ level, vocational experts are present at hearings to perform a transferable skills analysis. As I've discussed at all times over the 11 years and continuing, he was always on 24/7 constant narcotics to alleviate his spinal condition. There was nothing else that could be done to relieve his pain. And I think it's important to note that, as I said, again and again, Hartford recognized he was not going to work. At one point, it decided he wasn't going back to work and valued his claim, according to its own notes, at $255,000. And so it offered him $157,000 to buy him out. Now, it's interesting. If they value his claim at $255,000, why do they only offer him $157,000? Perhaps that's the conduct of a financially self-motivated insurance company and not an fiduciary. I think, well, with regard to what happened at the time of the termination, as you say, Hartford had three pieces of evidence. They had the Wolf FCE, which is, in my view, supportive of a finding of disability. They had an employability assessment review, which is basically totally unreliable. It doesn't take in the real world, and it also cherry picks the report by failing to acknowledge that he could only sit for 10 minutes at a time and couldn't use his hands. And Social Security has determined that for an unskilled sedentary position, a worker has to have use of his hands.
All right, thank you very much, Mr. Cantor. We appreciate it. All right, I've lost Judge Floyd here. Where is? courtroom deputy.
Okay, thank you, Your Honors. May it please the court, my name is Grace Murphy, and I'm here today on behalf of Appellees and defendants, Hartford Life and Accident Insurance Company, and the Hyatt Corporation Disability Plan. Judge Hilton's district court decision correctly assessed the record as a whole and the totality of the evidence, and applied Fourth Circuit law correctly in both striking plaintiff's post-exhaustion submission and in affirming Hartford's claims decision. So with the four corners.
So, counsel, do we owe Judge Hilton's decision any deference?
No, Your Honor, as I understand it, and I do concur with plaintiff's counsel that, as I understand it, the standard review is de novo. So you will be looking at this with fresh eyes.
So I don't understand here why you don't have an abuse of discretion provision in your plan, because you would be due a whole lot more deference if the plan read. But why? I mean, it would seem like such an obvious step to take to have an abuse of discretion provision in your long-term disability plan, but I couldn't find any.
Yes, Your Honor. The reason that the parties actually stipulated to de novo standard review, this policy was delivered in the state of Illinois. That's where Hyatt is headquartered and based. The plan is administered, and they have a state discretionary ban. So even if there is discretionary language, and I believe there may be, but even if there was, the operation of that statute we conceded resulted in application of the de novo.
What statute are we talking about?
It is an Illinois state statute, Your Honor, and it is in the joint appendix in our stipulation to.
Well, I know, but a national insurance company can have a plan and take cognizance of the fact that an abuse of discretion standard does not apply in the following states. And then you would have Illinois be one of those states, but companies do this all the time. They say this is not applicable, and so and so and so. I'm still perplexed as to why there's no abuse of discretion standard here, because we're not dealing with Illinois.
Yes, Your Honor. I think that there is case law, the choice of law provisions. The policy says the policy will be construed under the state where the policy was delivered, which is Illinois in this case. And I understand the standard of review is what it is, but we believe that the record here today still demonstrates that Hartford made the correct decision.
So let me ask you one other question about this. Normally, when people have the combination of ailments that this gentleman had, over time, most people as they get older, I hate to say this, but most people as they get older tend to go downhill or maybe not improve. But here you're trying to say, well, this person was on disability payments for over 11 years, and whoops, all of a sudden, he's fine. And I don't get it. I don't get how somebody can be on a disability payment for 11 years and suddenly be okay, unless there's some good explanation for it. But it just, obviously, age can present health problems that youth does not. And how does somebody just all of a sudden, after 11 years, multiple surgeries, pain issues, limited use of the hands, taking opioids to mask the pain, sitting, standing restrictions, and all of a sudden you say, oh, he's just fine. And I don't get it.
Your Honor, if I may, a couple of responses to that. This man was in his 30s when he first went out on claim. He had a surgery before awards were benefited. He then had surgeries in 2005 and 6, and he had a spinal cord stimulator implanted in 2010. At that point, Your Honor, we're looking at 6 years later from that. There is evidence of a slow and steady strengthening and stabilizing. He was at a, and if you want to call it marginal improvement, if you want to call it a stabilizing, there was a status quo at the time that Hartford it is charged with continuing to look at claims. It cannot be, it is an ERISA fiduciary. It would be a breach of that duty to award a claim and never touch a file again through the maximum payable period.
Well, counsel, let me ask you, other than the Wolf FCE and Dr. Lewis's report, what's your best evidence as to Mr. Shoup?
Your Honor, I think if you look at the narrative and the totality of the record to understand why the Wolf FCE was even suggested in the first place, I think you'll understand better the sequence of events. What happened was Mr. Shoup had not seen an orthopedist.
Well, I have to tell you, having gone back through Mr. Shoup's medical record, that's in our record, both before the Wolf FCE and what was submitted afterwards by Humbacker and somebody else, Woolcock. There doesn't seem to be much ground there for Hartford to hang its hat on.
Your Honor, in August 2015, Dr. Robinson, who was plaintiff's really only treating physician at that time of pain management, who was just monitoring, there was no change in treatment, he was just monitoring this ongoing treatment, submitted some restrictions and limitations in response to an attending physician statement. And taken together, it suggested that the plaintiff may have sedentary full-time capacity. So in doing its due diligence, Hartford reached out to Dr. Robinson to say, you know, you've submitted these, we're looking at it, would you agree that he has full-time sedentary capacity? Unbeknownst to Hartford, Dr. Robinson had actually left the practice and Dr. Wittenberg had stepped in to take over patient's care. She was the one who said, I cannot assess this without a functional capacity evaluation. So in good faith, Hartford then reached out and obtained the Wolf FCE, as we've discussed. And Wolf FCE, I think you need to look at as in its totality. Plaintiff has pointed to some things, but it was from about 11:30 in the morning till 5 o'clock at night. It spent a lot of time.
I realize what the Wolf FCE says, but then a few months later, you have the Humbacker examination, which doesn't do you all very much good.
Yes, Your
and
Honor.
It just looks like the Wolf FCE and Dr. Lewis's report are somewhat outliers in the long history of disability.
Your Honor, respectfully, I would disagree with that characterization. I think once the Wolf FCE came, they actually sent it back to Dr. Wittenberg, his pain management physician, and said, please take a look at this and see if you agree. Please call us if you want to discuss. Here's some blanks to fill in. And she checked unequivocally, I agree with the conclusions. Plaintiff has full-time sedentary capacity. That is when Hartford then did its employability analysis, and there were jobs that allowed him. And I think plaintiff's counsel has misread the FCE by saying he was actually required to stand up every 10 minutes. It suggested he was required to shift positions with tolerance. He was observed actually during the FCE sitting for 95 minutes with some positional changes, another 45-minute period. And so the jobs that we identified as representatives allowed for those positional changes.
Well, let me ask you this,
Yes,
Ms. Murphy. These jobs like assignment clerk, jacket preparer, batch records clerk, can they be done by somebody who's on drugs such as fentanyl?
Your Honor, on the question of any impairments from cognitive impairments, plaintiff's counsel testified that there was no need to do neuropsychological testing. I disagree with that. There is no real evidence of the extent of it. He was on his pain medication during the time of the FCE, and what Ms. Wolf said is that if he wasn't, maybe his pain would be increased. But what she did not say was that the pain medication affected his ability to do those activities in any way.
How could it not affect his ability? I don't understand that.
Your Honor, it is plaintiff's burden to prove establishment. There's his own Dr. Robinson in 2014 indicated that there were no cognitive impairments that plaintiff suffered. At times he said there were some cognitive impairments, but the question of whether his was cognitively impaired, plaintiff has never been able to demonstrate that that is true. And he has been able to engage in certain physical activities that he's been seen doing. He's lived on this pain medication for many years. He has reached a status quo.
If he'd gone on for all these years on the basis of disability because he can't sit, why would they need to also go into cognitive impairment at that time? I mean, if he was disabled purely on his physical inability to function, there's no legal requirement that he show alternatively a cognitive impairment, is there?
Your Honor, I believe there is an obligation on him to demonstrate the full extent of his disability. The physical requirements, he was, as his own doctors in fall of 2015 into early 2016 were saying he had the physical sedentary capacity. He had 240 days to appeal the case. While he had a vocational assessment that mentioned medication impairments they were all very speculative, and there was no pinpoint evidence that he himself experienced side effects from medication that prevented him from working in a full-time sedentary capacity in the occupations, sample occupations or otherwise that have been identified.
You say that he is stabilized at a certain point over this period, but did Hartford actually believe that? Because you can continue to provide him disability benefits over a long period of time, including a period of time in which you said, well, he had stabilized.
Your Honor,
but you still regarded him as disabled.
Your Honor, we deferred. We listened to his treating physicians. In 2013, there was an FCE that showed that he was not conditioned to return to work. It did not say he was. The main findings of that were that he was physically deconditioned. So at that point, we in good faith continued to pay benefits, allowing him additional time. And as he was observed and self-reported, his physical activities increased at that point. He was out repairing car stereos. He was driving. He was taking family members to medical appointments. He was out and about. And so when we continued to ask for, as it was our duty and requirement, to ask his doctors for their medical opinion on his functionality, when those, as of 2015, show that he, at that point, likely had sedentary capacity, Hartford went to the next step in trying to get his attending physician to speak to whether that was, and that's what triggered the FCE in 2016 that demonstrated the full-time sedentary capacity. Your Honor, there's some policy provisions here that I think we need to look at that speak to the concerns of this court. One is that the policy itself includes a continuing proof of disability clause, which provides that a claimant may be asked to submit proof that he continues to be disabled, and he must provide it within 30 days or risk delay, suspension, or termination of benefits. Also, the proof of disability language in this policy includes an objective medical findings requirement, that they must produce tests, procedures, or clinical examinations standardly accepted in the practice of medicine for his disabling condition. The last objective medical test was a 2015 CT scan. At that point, and again, in this trajectory of this claim, he was not going to be undergoing any more orthopedic treatments. He was living his life as he had with chronic pain. But as the Gallagher case has shown, chronic pain in and of itself is not enough to establish a disability. We must find that the plaintiff must meet his burden of showing that chronic pain prevents him from performing all occupations in this case. In the Gallagher case, indeed, it said that whether Gallagher's pain made him totally disabled, however, hinges on whether it made him incapable of performing all the duties of his occupation. In that case, the insurer had showed that there was marginal improvement, but there was no objectively satisfactory proof that he was disabled. We suggest that the same applies here at this case.
So, counsel, go ahead, Judge Wilkinson.
I just want to know how many spinal surgeries this individual has. Back surgery is always a little tricky, but how many surgeries on his spine did he have over this period?
He had, before he filed the claim, he had one, and then as I understand it, he had two. But the last one was in 2006, 10 years before benefits were terminated. He had a spinal stimulator implant in 2010. I'm not sure that that counts as a true spinal fusion, but I did want to mention that too.
So, counsel, just assuming for purposes of argument, if we were to agree with plaintiff's counsel that the district court ruling was erroneous, what do you say would be the relief that should be granted?
Your Honor, I think that the relief that would be granted is depending on how the opinion comes down. But I believe one of the options would be an award of past due benefits and a remand to Hartford to continue looking at this claim. This claim was terminated again in 2016. There can be no award of future benefits after that time, and there needs to be a review of the claim. It depends if this court finds that there was some piece of evidence that was missing or that plaintiff submitted and we didn't review or something to that extent. It can also remand with no award of past due benefits and just ask that Hartford take another look.
So, but I guess what I'm asking is, if we were to find for the plaintiff here, do we simply vacate and return to the district court for further proceedings, or do we vacate and return it to the district court with instructions?
I have seen it done both ways, Your Honor, and I think you have the leeway to do either one in the unfortunate event that you come down that way.
I'm just wondering what further proceedings would there be? It seems to me the record is, you go one way or another on the record, and I'm just not sure what holes in the record there are, or what further medical reports there would be, or whatever. I don't know. I'm just not sure what needs to be done. We've got a record. We might just have to sort of make the call one way or the other.
Well, Your Honor, we haven't discussed the ruling on the motion to strike at this time. Assuming that ruling stands and that plaintiff's post-exhaustion submission does not come in, then the record would be complete. If there is some inclination, and I would appreciate the opportunity to argue against that, but if that evidence from May 2017 does come in, then a remand would be more appropriate.
All right. Is there anything further, Ms. Murphy? I guess your time is pretty close to expired.
No, Your Honor, thank you.
We thank you. Mr. Cantor, you have some time for rebuttal.
Thank you, Your Honor. Before I start, may I inquire of the court if they have any questions they'd like answered?
Yeah, I have one.
Yes, sir.
As to that motion to strike, on this record, do you need that evidence in the record?
No.
Or do you, okay.
I don't need it. I think it was an error to exclude it under Quisenberry. First, I have the utmost and highest respect for my opposing counsel. I think she's an incredible lawyer. I do have to disagree with her statement, though, about that May letter from Dr. Wittenberg, where she characterized it as Dr. Wittenberg agrees with the conclusion that he can return to work. There's nothing in the Wolf report that says he can return to work. All she said was that she agrees with the findings, and the findings were he would only be able to sit for 10 minutes. So given the ambiguity of the Wolf report and Dr. Wittenberg seeking to clarify what she was saying, that she thinks he's still fully disabled, I would think that any court looking at this de novo would want clarification of what she meant. But I don't need it to come in. Following that,
so counsel, if we were to find in favor of Mr. Shoup, what do you say is the relief that should be granted?
I think the first thing Ms. Murphy said, which was benefits paid to date and a reinstatement to the plan for Hartford to further administer it. I agree, you can't order future benefits. We didn't ask for that. I think we should remember, before Mr. Shoup stopped working, he was earning close to $6,000 a month. When he goes out in disability, he drops to $3,500. When he's cut off by Hartford, all he has left is Social Security of about $1,100 a month. For the past 5 years, he's been living on $1,100 a month when he should have been getting $3,500. The axiom that justice delayed is justice denied is applicable here. This court, in my humble opinion, should find that he's entitled to benefits and direct the district court to order benefits reinstated.
Is there anything further, Mr. Cantor?
Just a point that might interest you, Judge Wilkinson, that you asked about the abuse of discretion. I would point out that Mr. Shoup, at the time he was employed, was working in California. California has a ban on discretionary provisions. So if you're talking about the state in which the insured was employed, it was not Virginia, it was California. The case was filed in California, and Hartford moved to transfer it to Virginia because that's where he was residing at the time of the denial.
So is it the California ban that's applicable?
Well, no, it could be the California ban, but I think more appropriately it is the Illinois ban. But if the Illinois ban applies to the state in which you're residing, he was residing in California. But the Illinois ban prohibits discretionary clauses to be included in group policies issued in the state of Illinois, which this policy was.
All right, thank you. Do you have any further questions, Judge Agee? Judge
No,
Floyd,
sir.
No, I don't.
Thank you, Your Honor.
If there's no further question, I want to thank you both. Can't come down and shake your hands, but we're very appreciative of the arguments that both of you have made. I hope you have a nice afternoon.
Thank you, Your Honor.
I'll ask the courtroom to adjourn court sine die.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I will move you to the robing room.
All right. Thank you for